some Supreme Court cases, and some other court cases, appellate court cases from different states that I find interesting. Carlisle versus the United States, 83 U.S. 147, 154, 1873. The rights of sovereignty extend to Let's see what I can do here. There we go. The rights of sovereignty extend to all persons and things not privileged that are within the territory. They extend to all strangers, residents therein, not only to those who are naturalized and to those who are domiciled therein, having taken up their abode with the intention of permanent residence, but also to those whose residence is transitory. All strangers are under the protection of the sovereign while they are within his territory and owe a temporary allegiance in return for that protection. In Liburg versus Vitangeli, 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 70 Ohio Appellate Court, 479-47 NE 2D 235-238-39. The case was had in 1942. These constitutional provisions employ the word person, that is, anyone whom we have permitted to peacefully reside within our borders may resort to our courts for redress of an injury done to him in his land, goods, persons, or reputation. The real party plaintiff, for whom the nominal plaintiff sues, is not shown to have entered our land in an unlawful manner. We said to her, you may enter and reside with us and be equally protected by our laws so long as you conform thereto. You may own property and our laws will protect your title. We, as a people, have said to those of foreign birth that these constitutional guarantees shall assure you of our good faith. They are the written surety to you of our proud boast of the United States is the haven of refuge of the opposed of all mankind. United States versus Minker, 350 U.S. 179, 1956. Those safeguards would be imperiled if prior to the institution of the proceedings, the citizen could be compelled to be a witness against himself and furnish out of his own mouth the evidence used, included within the protection of all the guarantees of the Constitution. Courts will assign to common law terms their common law meanings unless legislator directs otherwise. People versus Young, 1983, 340, N period W period 2D, 805, 418, Michigan 1. Common law by Constitution is law of state. Beech Grove, INV Co. versus Civil Rights Common, 1968, 157, N period W period 2D, 213, 380, Michigan 405. Common law is but the accumulated expression of various judicial tribunals in their efforts to ascertain what is right and just between individuals in respect to private disputes. Simmons versus Floyd Rice Ford Incorporated, 1965, 136, N period W period 2D, 704, 1 Michigan Appellate Court, 395. The right to make a common law dictation is not abrogated by the statutory regulations providing for the right to make common law dedications is not abridged by the statutory regulations providing for dedication in certain specific ways. Village of Granville versus Jensen, Jenison, 1890, 47, N period W period 684, Michigan 54, affirmed 49, N period W period 544, 86, Michigan 657. The common law is in force in Michigan, except so far as it is repugnant to or inconsistent with the Constitution or statutes of the state. Stout versus Keys, 1845, 2 Doug 184, 43, Am, December 465. The Constitution was ordained and established by the people of the United States for themselves, for their own government, and not for the government of the individual states. Each state established a constitution for itself, and in the Constitution provided such limitations and restrictions on the powers of its particular government, as its judgment dictated. The people of the United States framed such a government for the United States as they supposed best adapted to their situation and best calculated to promote their interests. The powers they conferred on this government were to be exercised by itself, and the limitations on power, if expressed in general terms, are naturally and we think necessarily applicable to the government created by the instrument. They are limitations of power granted in the instrument itself, not of distinct government, framed by different persons and for different purposes. If these propositions be corrected, the Fifth Amendment must be understood as restraining the power of the general government, not as applicable to the states. Code is not law in regards to Self versus Ray, 61 WN 2D 261, defined in Black's Law Dictionary as prima facie, which is color of law. Color is counterfeit or finged. The real law and the common law, as described in the above cases and the code itself, the people are not subject to the law generally, Yick Woo versus Hopkins, 118 U.S. 356, 370, except for the criminal code that are codified common law. Sovereignty itself is, of course, not subject to the law, for it is the author and the source of the law. But in our system, while sovereign power are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts, and the law is the definition and limitation of said power. For the very idea that one man may be compelled to hold his life or the means of living or any material right essential to the enjoyment of life at the mere will of another seems to be intolerable on any country where freedom prevails, as being the essence of slavery itself. See Yick Woo versus Hopkins, 118 U.S. 356, 1886. He is not to substitute even his juster will for theirs. Otherwise, it would not be the common will which prevails, and to that extent, the people would not govern. See speech by Judge Learned Hand at the Mayflower Hotel in Washington, D.C., May 11th, 1919, entitled, Is There a Common Will? The Congress cannot revoke the sovereign power of the people to override itself as thus declared. See Perry versus the United States, 294 U.S. 330, 353, 1935. In the United States, sovereignty resides in the people who act through the organs established by the Constitution. See Chisholm versus Georgia, 2 Dallas 419 471, Penhallow versus Dones, Administrators, 3 Dallas 5493, and McCulloch versus Maryland, 4 Wheat, 316 404 405, Yick Woo versus Hopkins, 118 U.S. 356 370, and 1886. We the people do ordain and establish the Constitution for the United States of America. See Preamble of the United States Constitution, 1789. The enumerated in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. See Article Exodus 10. See Article 6 of the U.S. Constitution. No, that wouldn't be 6. What the hell would that be? 1 second. I gotta learn my Roman numerals. Boom. All right, Article 9. Let's go back. Article 9, U.S. Constitution. As men whose intentions require no concealment generally employ the words which most directly and aptly express the ideas they intend to convey, the enlightened patriots who framed our Constitution and the people who adopted it must be understood to have employed the words in their natural sense and to have intended that what they have said. See Gibson versus Ogden, 27 U.S. 1. No legislator can bargain away the public health or public morals. The people themselves cannot do it, much less their servants. See New Orleans Gas Co. versus Louisiana Light Co. 115 U.S. 650, 1885. For it can never be maintained in any tribunal in this country that the people of the state, in the exercise of the power of sovereignty, can be restrained within narrow limits than that fixed by the Constitution of the United States. The people of a state may, by the form of government they adopt, confer on their public servants and representatives all the power and rights of sovereignty which they themselves possess, or may restrict them from such limits as may be deemed best and safest for the public interest. See Ohio Life Insurance Company and Trust Co. versus DeBolt, 16 HOW 415 428-9. The phrases used in the Constitution does not mean a statute passed for the purpose of working the wrong. The construction would render the restriction absolutely nugatory. The people would be made to stay to the houses. You shall be vested with the legislative power of the state, but no one shall be disenfranchised or deprived of any of the rights or privileges of a citizen unless you shall not do the wrong unless you choose to do it. See per Bronson J. in Taylor versus Potter, 4 Hill, New York, 1:40 a.m., D.C., December 274. People are supreme, not the state. See Waring versus the mayor of Savannah, 60 Georgia at 93. Strictly speaking, in our republic form of government, the absolute sovereignty of the nation is in the people of the nation, and the residuary sovereignty of each state, not granted to any of its public functionaries, is in the people of the state. See 2 Dallas 471, Bovier's Law Dictionary, 1870. I believe there are more instances of the abridgment of the freedom of the people by the gradual and silent encroachment of those in power than by violent and sudden usurpation. James Madison. The theory of the American political system is that the ultimate sovereignty is in the people, from whom all legitimate authority springs, and the people collectively acting through the medium of constitutions create such governmental agencies, endow them with such power, and subject them to such limitations as in their wisdom will best promote the common good. See First Trust Co. versus Smith, 134 Nebraska, 277 SW 762. What is a constitution? It is the form of government delineated by the mighty hand of the people in which certain first principles of fundamental laws are established. See Van Horn's Lisi versus Dorrance, 2 U.S. 304, 1795. The Constitution is designated as the supreme enactment, a fundamental act of legislation by the people of the state. A constitution is legislation direct from the people acting in their sovereign capacity, while a statute is legislation from their representatives, subject to limitations prescribed by the superior authority. See in Lingham versus Dye, DYE, 178, Indiana, 336, 99 NE1, 231 US 250, 58 L period ED period 206, 34 S period CT period 92, Sage versus New York, 154 NY 6147 NE 1096. The question is not what power the federal government ought to have, but what powers, in fact, have been given by the people. The federal union is a government of delegated powers. It has only such as are expressly conferred upon it, and such as are reasonably to be implied from those granted. In this respect, we differ radically from nations where all legislative power without restriction of limitation is vested in a parliament or other legislative body subject to no restrictions except the discretion of its members. See U.S. versus Williams M. Butler, 297 U.S. 1. The people themselves have in their power effectually to resist usurpation, without being driven to an appeal in arms. An act of usurpation is not obligatory. It is not law, and any man may be justified in his resistance. Let him be considered as a criminal by the general government, yet only his fellow citizens can convict him. They are his jury, and if they pronounce him innocent, not all powers of Congress can hurt him. And innocent they certainly will pronounce him, if the supposed laws he resisted was an act of usurpation. See 2 Eliot's Debate, 94, 2 Bancroft, History of the Constitution, 267. But it cannot be assumed that the framers of the Constitution and the people who adopted it did not intend that which is the plain import of language used. When the language of the Constitution is positive and free from all ambiguity, all courts are not at liberty, by a resort to the refinements of legal learning, to restrict its obvious meaning to avoid hardships of particular cases. We must accept the Constitution as it reads when its language is unambiguous, for it is the mandate of the sovereign powers, the people. State versus Sutton, 63 Minnesota 147, 65, WX N period W period 262 101 N period W period 74, and Cook versus Iverson 122 N period M period 251. In this state, as well as in all republics, it is not the legislation, however transcendent its power, who are supreme, but the people, and to suppose that they may violate the fundamental laws is, as has been most eloquently expressed, to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that the men acting by virtue of delegated powers may do not only what their powers do not authorize, but what they forbid. See Warning versus the Mayor of Savannah, 60 Georgia, page 93. There have been powerful hydraulic pressures throughout our history that bear heavily on the court to water down constitutional guarantees and give the police the upper hand. That hydraulic pressure has probably never been greater than it is today. Yet, if the individual is no longer to be sovereign, if the police can pick him up whenever they do not like the cut of his jib, if they can seize and search him in their discretion, we enter a new regime. The decision to enter it should be made only after a full debate by the people of this country. See Terry versus Ohio, 392 U.S. 39, 1967. Criminal Law and Procedures, People versus Thompson, number B 176808, California 2D Appellate Court, District, November 17, 2004. Warrantless entry into a residence to detain a suspect for removal outside for possible identification and possible citizen's arrest does not fall within the hot pursuit exception to the Fourth Amendment. Barrett versus Stenville City School, number 03-4373, 6th Circuit Court, November 15, 2004. Parents have a constitutionally protected liberty interest in raising and directing the education of their children, and a state employer cannot condition employment upon the waiver of that right. Personal liberty, or the right to enjoyment of life, liberty, is one of the fundamental or natural rights, which has been protected by its inclusion as a guarantee in the various constitutions, which is not derived from or dependent on the U.S. Constitution, which may not be submitted to a vote and may not depend on the outcome of an election. It is one of the most sacred and valuable rights, as sacred as the right to private property, and is regarded as inalienable. 16 Corpus Juris Secundum, Constitutional Law, Section 202, page 987. Sovereignty in itself, of course, not subject to the law, for it is the author and source of the law. But in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains in the people, by whom and for whom all governments exist and act. And the law is the definition and limitations of power. For the very idea that one man may be compelled to hold his life or the means of living or any material right essential to the enjoyment of life at the mere will of another seems to be intolerable in any country where freedom prevails, as being the essence of slavery itself. Yick Woo versus Hopkins, U.S. 356, 1886 was the year of the case. The Congress cannot revoke the sovereign powers of the people to override their will as thus declared. Perry versus United States, 294, U.S. 330, 353, 1935 was the year of the case. In the United States, sovereignty resides in the people who act through the organs established by the Constitution. Chisholm versus Georgia, 2 Dallas, 419, 471. Penhallow versus Doan's administration, 3 Dallas, 54, 93. McCulloch versus Maryland, 4 Wheat, 316, 404, 405. Yick Woo versus Hopkins, 118 U.S. 356, 370. As men whose intentions require no concealment generally employ the words which most directly and aptly express the idea they intend to convey, the enlightened patriot who framed our Constitution and the people who adopted it must be understood to have employed the words in their natural sense and to have intended what they have said. Gibson versus Ogden, 27 U.S. 1. City of Dallas versus Mitchell, 245, S.W. 944. The right of the individual are restricted only to the extent that they have been voluntarily surrendered by the citizenship to the agencies of the government. Hurtado, Hurtado, versus People of State of California, 110 U.S. 516, 1884. At page 533 of the ruling on constitutional rights held by the people, indeed, the great office of statutes is to remedy defects in the common law as they are developed, and to adapt it to the changes of the time and circumstances. At page 535 of the ruling, it is not every act legislative in form that is law. Law is something more than mere will exerted as an act of power. Chicago and GTR Co. versus Wellman, 143 U.S. 339, 1892. At page 345 of the constitutional ruling of rights retained by the people whenever in the pursuance of an honest and actual antagonistic assertion of rights by one individual against another, there is presented a question involving the validity of any act of any legislator, state, or federal, and the decision necessary rests on the competency of the legislator to so enact. The court must, in the exercise of its solemn duties, determine whether the act be constitutional or not. But such an exercise of power is the ultimate and supreme function of courts. It is legitimate only in the last resort and as a necessity in the determination of real, earnest, and vital controversies between individuals. It never was the thought that by means of a friendly suit, a party beaten in the legislature could transfer to the courts an inquiry as to the constitutionality of the legislative act. Mutual Loan Insurance Co. versus Martell, Martell, 222 U.S. 225, at page 233 of the ruling on constitutional rights of the people. Certain general principles, however, must be taken for granted. It is certainly the province of the state by its legislator to adopt such policies as it seems best. There are constitutional limitations, of course, but these allow a very comprehensive range of judgment, and within the range of the Massachusetts statute can be justified. Legislation cannot be judged by theoretical standards. It must be tested by the concrete conditions which induced it. Supreme Court Justice Brandeis spoke in the case of Olmstead versus the United States when he said, Decency, security, and liberty alike demand that government officials shall be subjected to the same rules of conduct that are commanded to the citizens. In a government of laws, existence of the government will be imperiled if it fails to observe the laws scrupulously. Our government is the potent, omnipresent teacher. For good or ill, it teaches the whole people by its example. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. To declare that in the administration of criminal laws, the ends justifies the means, to declare that the government may commit crimes in order to secure the convictions of a private criminal, would bring terrible retribution. Against the pernicious doctrine, this court should resolutely set its face, and should every law enforcement student, practitioner, supervisor, and administrator. A constitution is designated as the supreme enactment and fundamental act of legislation by the people of the state. A constitution is legislation direct from the people acting in their sovereign capacity, while a statute is legislation from their representatives, subject to limitation prescribed by the superior authority. Ellingham versus Dye, 178 Indiana 336, 99 NE 1, 231 US 250, 58 L.ED 206, 34 S.CT 92, Sage versus New York, 154 New York 61, 47 NE 1096. U.S. versus Lee, 106 U.S. 196, 1882. Under our system, people who are there called subjects are the sovereigns. Their rights, whether collective or individual, are not bound to give way to a sentiment of loyalty to the person of the monarch. The citizen here knows no person. However, near to those in power, or however powerful himself, to whom he need yield the right which the law secures to him when it is well administered. When he, in one of the courts of competent jurisdictions, has established his right to property, 106 U.S. 196 209, there is no reason why difference to any person, natural or artificial, not even the United States, should prevent him from using the means which the law gives him for the protection and enforcement of that right. The term liability denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, to establish a home and bring up children, to worship God according to the dictates of his own conscience. The established doctrine is that this liberty may not be interfered with under the guise of protecting public interest by legislative actions. Meyer versus Nebraska, 262 U.S. 390, 399, 400. No legislator can bargain away the public health or the public morals. The people themselves cannot do it, much less their servants. See Police Power, New Orleans Gas Co. versus Louisiana Light Co., U.S. 650, 667. For it can never be maintained in any tribunal in this country that the people of the state, in the exercise of the power of sovereignty, can be restrained within a narrower limits than that fixed by the Constitution of the United States. The people of the state may, by the form of the government they adopt, confer on their public servants and representatives all the power and rights of sovereignty which they themselves possess, or may restrict them with such limits as may be deemed best and safest for the public interest. See Police Power, Ohio Life Insurance and Trust Co. versus DeBolt, 16 Howell, 415, 428-9. The phrase as used in the Constitution does not mean a statute passed for the purpose of working the wrong. The construction would render the restriction absolutely nugatory. The people would be made to stay to the houses You shall be vested with the legislative power of the state, but no one shall be disenfranchised or deprived of any rights or privileges of a citizen unless you shall not do the wrong unless you choose to do it. Per Bronson J. in Taylor versus Potter, Fort Hill, New York, 140, 40 a.m., December 274. People are supreme, not the state. Warning versus the mayor of Savannah, 60 Georgia, 8 at 93. We can come back. Where did that go? When we come back, we'll get into some other goodies here. We'll get into Congress being barred. Before we go any further, we'll do this one. The belligerent claimant. The privilege against self-incrimination is neither accorded to the passive restraint nor the person who is ignorant of his rights, nor to the one indifferent thereto. It is a fighting clause. Its benefits can be retained only by sustained combat. It cannot be retained by attorney or solicitor. It is valid only when insisted upon by a belligerent claimant in person. The one who is persuaded by honeyed words or moral suasion to testify or produce documents rather than make a last-ditch stand simply loses the protection. Once he testifies to court, he has waived his right and must, on cross-examination or otherwise, testify as to the whole transaction. He must refuse to answer or produce and test the matter in contempt proceedings or by habeas corpus. District Judge James Alger Fee, United States versus Johnson, 76 F. period, Superior Court period, 538 at page 540, District Court, MD, Pennsylvania, February 26, 1947.